We're here this morning on State versus Adelson, 2023 CF 3226, the defense's motion to change the venue of the trial. Parties may make their appearances.
Georgia Kappelman for the state. Sarah Catherine Dugan for the state.
Jackie Fulford on behalf of Mrs. Adelson.
Joshua Zellman on behalf of Mrs. Adelson.
And I will note the defendant is present in the courtroom for the evidentiary hearing as well. Before we get started with taking of the testimony of the witness, Mr. Murphy, I believe he's going to be the only witness for the defense today. Is that correct?
That's correct, Your Honor.
All right. In reviewing the motion, the affidavits in support, and also the memorandum of law, I wanted to make sure the state had not filed a formal response. You were planning to make your argument today. Is that correct?
That's correct, Your Honor.
Very well. As to the affidavits in support, Mr. Zellman in particular, I saw that you had placed an affidavit concerning this matter, specifically for the court to consider this as it goes to both being advocate and witness in the same matter. How exactly is that to take place?
Your Honor, the rule requires an affidavit of 3 individuals, one being the defendant and 2 other individuals. It does not identify who they are, and also does not require that those individuals testify.
Again, you are the primary counsel for your client, correct?
Yes, Your Honor.
So as to your legal arguments and also your factual affidavit in support of, you believe the court can properly take notice of both?
Yes, Your Honor.
Does the state have any argument concerning those?
No, sir.
Very well. As to whether there's any issue with court accepting that as evidence, I will conduct my own research, but we will move forward at this point. I do see Mr. Murphy is already in the Zoom. Mr. Murphy, good morning, sir. I think you're muted right now.
I only do this 10 times a day. Good morning, Your Honor. My apologies.
Good morning. Good to see you. The technology helps it be more convenient, but at the same time, well, at least you're not like the lawyer who was, I believe, on the Zoom saying I'm not a cat.
The morning is young, so I'll try to avoid that.
We're doing much better in that regard. All right, I believe previously in preparing for the hearing today, the time allotted was going to be 2 hours to the defense to make their presentation. The state would have a half hour to respond. I will go ahead and swear in Mr. Murphy, and the defense's time will begin at that point. Mr. Murphy, please raise your right hand to be sworn, sir. Do you swear or affirm the testimony you're about to give today as a part of this proceeding will be the truth?
Yes, I do.
You may lower your hand. Mr. Zellman, you may examine the witness when you are ready.
Thank you, Your Honor. I have a number of exhibits that we discussed the other day on a flash drive. May I approach with that?
You may. This is a newer version of this binder.
Some of the information has been updated. Yes, Your Honor.
All right. Is there any objection from the state as to the court considering this as admitted evidence for the defense for the hearing?
No, Your Honor.
The jump drive will be defense 1. You may continue.
So the way that I have the drive organized, Your Honor, there are 6 folders. Exhibit 1, Exhibit 2, and Exhibit 3 are materials from TrueScope. Can I have permission to share my screen so that Mr. Murphy can?
You may.
So the Exhibit 1 is TrueScope's raw data that we had previously submitted. Exhibit 2 is the original report from TrueScope, and Exhibit 3 is the updated report that was finalized. We'll be going through those, and just by way of a brief opening, Your Honor, if I may.
Go ahead.
It goes without saying that the 6th and 14th Amendments to the United States Constitution, as well as Article 1, Sections 9, 16, and 22 of the Florida Constitution, guarantee an accused a fair trial by an impartial jury. With that, Your Honor, I guess you've already sworn Mr. Murphy. Mr. Murphy, can you please introduce yourself to the court?
Yes, my full name is James Todd Murphy. I'm president of TrueScope in North America, media intelligence and analysis service.
And what is media intelligence and analysis?
Media intelligence is the overall term given to our industry that includes media monitoring, media analysis. It's kind of two components to the single industry. Media monitoring is the action of tracking and indexing and reporting media across or stories from media of all types. And then media analysis, sometimes called insights, is the analysis of that data, looking at both qualitative and quantitative information, using a framework that is that can repeat valid results.
How does TrueScope gather that media?
We have two primary, or I would say two different methods. One is we use aggregators that pool content. So for like the broadcast data, we have a party that records all designated market areas, or those maybe simpler to think of those as cities. There's 210 city markets in the United States that are monitored. For example, New York City is number one, and it's based on the size of the market area. So for TV and radio, we aggregate all that, and it comes to us in a feed that has metadata attached, so we know the date, time, station, and then the video is indexed to a timestamp. We do the same thing with radio, podcasts. On the print side, we actually scan much of that, although we do receive feeds from partners of scanned and indexed data. Those generally are sent to us directly from the publishers as PDF images with the text layer behind it. So there's really no break in the chain coming from them for their printed media. We do the same thing with magazines. Social media, it's more of a feed from each social network. Facebook has a feed, Instagram has a feed, LinkedIn, etc. Online news, we use a system where a crawler crawls the web, pulls back anything that has changed, that then gets put into a feed. And these feeds all come into us via an API, which is basically just a conduit for communication. All of that comes into our server or servers that are hosted on Amazon, where that data is then processed into topics, and additional supplemental, I call it metadata, additional data is added to that. Who's named in here? What industries are mentioned? And all of that then is indexed so we can run queries against that and report just specific topics. So if Judge Everett wanted a report each morning, for example, of anybody talking about him, he would get, at whatever specified time, a report of all media, or if there's no media today, he would get a report saying there's no news about you. That's the media monitoring side. The media analysis side then takes all that data that we've captured for a specific topic, and we run some automated systems against that to generate media dashboards, charts, graphs. That's mostly for the quantitative side. Once the quantitative side has been developed, then we apply a methodology for the qualitative analysis. And stop me if I'm going too deep for this question.
No, this is perfect. Please continue.
Okay, so once we have the quantitative, we create the qualitative frame, using the methodology within our framework for the qualitative data. And that's currently based on the Barcelona principles, Barcelona 3.0 principles, as set out by the Global Measurement trade association called AMEC, A-M-E-C. So we use the AMEC principles to make sure that we're using best practices in evaluating the media that we've monitored.
Now, let's talk a little bit about your background and training. Can you tell the court about your background in media intelligence and analysis, please?
Without sounding, I guess maybe too folksy, my family has been in the industry since before I was born. My father purchased a press clipping service, as they were called, in the late 50s. I began broadcast monitoring when I was 15. He wanted to add the TV and radio side, so I technically set that up for him. And graduated from college in 1991, began full-time, and then developed additional services like competitive media analysis, qualitative media analysis, and others.
You said you graduated from college. What is your degree in?
I got a degree in radio, television, and film, and a minor in psychology.
Beginning in 1991, can you advise the court exactly what it was that you developed through the company? And it wasn't called TrueScope back then, was it?
No, it was, initially it was called Universal Press Clipping Bureau, founded in 1908. In 1998, I changed the company name to Universal Information Services, and then in January of 2023, I merged the company with a technology firm out of Australia by the name of TrueScope, taking on the name TrueScope in that month.
Can you tell the court a little bit about your other qualifications in the field of media intelligence and media analysis?
Sure. As you might imagine, a person who is born into it and grows up from a young age in it, I've held all the leadership roles in all of our trade associations, which includes IABM, which was the International Association of Broadcast Monitors, NDS, which was the News Data Services Cooperative, the NACPCS, National, it's a press clipping. It was an early press clipping conference. I can't remember the exact acronym right now, but it was a North American Conference of Press Clipping Services. There we go. My apologies, Your Honor. Let's see, after that, became a member of AMEC to add the measurement side, and have held North American leadership roles there, and currently am president of FEBEC, which is the global trade association over all MMO, the entire media monitoring organization industry, which constitutes both both media monitoring and media analysis companies.
Now, in addition to that, have you yourself also developed software that is now used in the industry?
Yeah, in the 90s, I had two primary developments. One, in 1995, developed the methodology for comparative media analysis, which was transparent, allowed you to see all the data behind the figures and the inferences, and allowed you to compare one entity against another. In the commercial realm, it might be a market, say Chicago, for example, that has a multitude of healthcare systems. It would allow one healthcare system to track how they're performing, both in terms of volume of media mentions, impact, reach, and then the qualitative side, primary message points where they either are leading or trailing their competitors. I also developed the first software and database and hardware solution that allow you to track multiple TV stations. The closed captioning that's embedded in broadcast programming, I had a program written that could extract multiple channels 4 channels simultaneously, all to a single database and that was the first instance of indexing broadcast media, which has come in handy when people try to trademark and patent that process. Having that prior art has helped me.
Have you previously testified as an expert in media intelligence and analysis?
I have.
Okay. Approximately how many times?
I think this will be my 5th formal testimony. We've done consulting for attorneys all along where they simply receive the data. But in terms of testimony similar to this would be my 5th time. Probably an equal number of our data plus an affidavit have been sufficient. If that's sufficient for your answer.
Thank you. Your Honor, we would tender the witness as an expert in media intelligence and analysis.
The state wished to voir dire the witness.
No, Your Honor.
The court at this time will permit the witness to testify in the form of an opinion during this hearing as to the specific topics. I believe it was media analysis and what was the other?
Intelligence.
And media intelligence. You may continue.
Thank you. Now, in the field of media intelligence and media analysis, in addition to gathering this data, you also have to quantify that, and that requires math, correct?
Correct.
And the mathematical principles that you use are generally accepted in the field of media intelligence and media analysis, correct?
Yeah, that is correct.
And in addition to the math concerning that issue, is it also generally accepted in your field to use similar mathematical principles to identify how many times somebody would have to see something in order to form a memory, and there's a standard formula for that we're going to go over, correct?
That is correct.
Okay. Now, on a factual level, how closely have you followed the murder of Dan Markel in the state of Florida versus Donna Adelson?
I have not followed it at all. Personally, as a standard operating procedure, I tend to avoid news such as that on the principle that we may have a client that we serve in this capacity. Certainly once engaged by a client to evaluate a specific case, I will call it, I tune out completely and avoid all media related to it. Just on the outside chance, I might see something that subconsciously would influence my opinion. Now, anytime you frame something, for example, you're looking at me right now and you're forming an opinion about how I look, that's the principle I apply. If I were to see a television news story, it's through the lens of a reporter. Even if it's an unbiased story or what we might call a balanced story, it's still framed, and what's in the frame, or what they might call the mise en scène, things in the frame can also influence. So as a person in my capacity, I avoid specifics related to a case we have, if not before.
Now, how has TrueScope collected the data in this case?
So in this case, all of the data has been gathered through our standard operating procedure through our aggregate systems, transmitted via API calls into our servers for indexing, processing. The text is never modified. The data that we receive from the media outlet is never modified. It's simply categorized and basically labeled so it can be recalled and have additional information telling us who, what, where, when, why, what time, that type of information.
And
That, go ahead.
No, please.
And then that information for a client or a case such as this is analyzed and managed by my media analysis team under the direction of Cheryl Lewis.
And the way in which the data was gathered in this case followed the generally accepted methodology in your field?
Yes. So one of the things, we have 2 layers of check and balances above each of our departments. Jean Saucier, who oversees, she's my senior vice president, oversees that department. She checks to make sure that progress towards a timeline is being made, but also that each step in the process is followed. Within the media measurement team, they have 2 people, and they have a rule that 2 sets of eyes look at everything. So anytime a spreadsheet is created, the assistant media analysis person on this job would review it, trying to find any errors in the data. And then lastly, which I think you've been a part of, Mr. Zellman, is I review all the data with the team, and I ask for additional things that I want to see. It could be volume of mentions over time or something else. So I don't look at the data prior to the nearly final reports, and then I say, okay, is there something missing in this situation? And ask for them to produce that.
Now, in doing so, you talked about a spreadsheet earlier. TrueScope prepared a spreadsheet of the raw data in this case, correct?
Yes.
Is the spreadsheet that is on the screen the raw data that TrueScope collected?
That is our data.
Okay. Now, there are a number of tabs. What is the purpose of having these different tabs at the bottom?
The different tabs, generally speaking, or simply put, correlate to what queries resulted in the data found. So, for example, this first tab that you're currently showing would be a query for either Donna Adelson or Charlie Adelson. Potentially would include any variations on their name that would then be reviewed to make sure it's the correct Charlie or Donna Adelson. Each row on the spreadsheet then represents a single article or story or unit of reporting, whether it's a TV story or a website article. Moving across the row, you're going to see all the metadata that is included with each story.
Okay. And can you tell the court how many articles, and this appears to be newspapers?
Yes.
Okay. How many different mentions were found? And what was the time period that TrueScope was searching?
So we looked at a couple of different slices. Some of it came back further than others to do some comparative analysis, I know. But overall, I believe we went as far back as 2014 to 2025 for some of the data. And then we also did a June 2023 to May 2024 sample analysis.
And so there
I'm not sure that answered your question directly, though.
With the newspapers, this tab indicates there were 233 mentions of Donna or Charlie Adelson during that time period, correct?
That is that's exactly correct. 233 rows, but the first row would be headers.
Okay. And then, can you tell the court what this second tab is?
That would be another query, a new query, that's not looking specifically for either Donna or Charlie Adelson, but additional names associated with this case that you or the client would ask us to look at either for comparison purposes or whatever they need. We generally don't offer legal advice on what you need for your situation, but the advice we give is how we've done this in the past and our expertise in doing it in the past, and we would suggest, are there additional people involved in a subject that should also be queried to see how many stories mentioned them, and in what relation to the overall subject you're most interested in.
So with respect to this tab, the searches were done for the alleged co-defendants or co-conspirators, McBanawa, Garcia, or Rivera, correct?
Correct, and although we just have last names listed, again, we would have ensured that we were using first names and variations that correlate directly to those individuals.
And for this tab, there were 308 mentions of those, of the alleged co-conspirators, correct?
That is correct.
What is this next tab?
That's going to be more of a, I'd call it a specific media type analysis. So it's a media type within a specific name query. So in this case, we were looking at queries of Dan Markel, or a search term of Dan Markel, in both broadcast and some web content.
Okay, now the dates in the first column, the formatting is a little off, but what does that represent?
That would be the date. That would be the date of broadcast. So in that first, or what is designated as row 2, that story aired on January 8th, 2014, at 5:34 p.m.
Was it January or was it August?
Oh, thank you. Because our technology is built in Australia, our dates are day, month, year, as opposed to month, day, year, as is more commonly used in the United States. We provide this service on a global scale, so even I have to remember that. My apologies.
Now, in this tab of information, does this include closed captioning from television newscasts or broadcasts?
It does, that's correct. So that's text inputted or live captioned by the broadcasting station or network.
And this also includes the link to that raw data, correct?
Correct.
And can you tell the court how many mentions there were, how many articles or broadcasts?
2,818.
And then what does this next tab represent?
So this is going to be what we call internally the roll-up of the quantitative data related to different views. So in this case, we're looking at cities or potential designated market areas. We include what county they reside in, and then we calculate and the system tabulates the exact amount that each of those cities and or counties, how much the volume of media mentions, so that would be the number of stories or articles or web pages within that geographic area. Column D would indicate the total audience. People may be more familiar with the Nielsen ratings That's where those audience figures come from. Sometimes you'll see them referred to as impressions. That often is a more generic term that can apply to other media types. But in terms of broadcast, that would be the Nielsen audience rating based on their methodology and their standard for establishing how many people had an opportunity to view that story in a specific geographic region.
And so, would it be accurate to say that your team looked at the total amount of articles and broadcasts that were identified in the previous tabs and then sorted them based on market area?
That is correct.
And the total number of broadcasts or articles that were published and TrueScope was able to collect, what was the total for Leon County?
2,371.
And then where did you get the total number of adults in Leon County from?
That would be from the most recent census numbers from the government. So that's obviously census.gov has that data. We use that data to pull the most accurate count as each census is updated.
And can you explain to the court what an opportunity or to be seen or impressions per person represents?
Sure. So whether it's a tabulated audience or unique visitors to a website, each media type has their own type of audience count calculation or impressions. Since the simple math takes the total number of stories and then divides that into the population of an area that we're looking at. So you take column C and column E and you can come up with, including column D, you can come up with a calculation just on basic math where on average, an individual residing in that geographic area would have X number of opportunities to see this specific story, whether it's hurricanes or a story about a hurricane or the subjects within this case.
Before you continue, Mr. Zellman, I do have a question on that point. Mr. Murphy, is the opportunity to be seen the same thing as definitive proof of engaging with that particular content?
It can't be, engagement can't be measured in what I call the passive mediums. That's going to be television, radio, because you might turn on a radio station in your car and listen to the news on your way to work, but I can't say that you necessarily engaged with every story. You may be a sports person and you're just waiting for them to get through the weather. So opportunities to be seen is I'll call it a more objective label to put on it when the media is passive. When it's an active medium like social media, we do have the ability to calculate engagements, like if you liked it, if you shared it, if you commented. So we do use the more objective opportunities to be seen to calculate the potential of an average adult or jury eligible individual within that geographic area to see a story.
Please continue.
Thank you, Your Honor. Now, in addition to conducting this analysis for Leon County, did you look at other counties in Florida?
We did.
Okay. And we're going to go through that in the next exhibit in more detail. I'm now going to pull up Exhibit 2. Is Exhibit 2 on your screen?
It is.
Okay. And can you tell the court what this exhibit represents?
This is going to be the output. It undoubtedly goes through several revisions until it passes all of our checks and balances, but this is a platform where we can visualize the data and annotate specific interpretations or inferences from the data to indicate to our client what a chart or graph or image might be showing in terms of their analysis on that page.
Now let's go to that first slide. What does this first slide represent?
It's very small on my screen. One moment. So that would be similar to what we saw on the previous exhibit. This is the media coverage for nearly an 11-year period by county, from designated counties in Florida.
And what counties, so Leon County, this is the 376 opportunities to be seen or potential impressions that we discussed previously. What other counties did you focus on? And we'll get to that in the next exhibit, but with respect to Miami-Dade County, what were the number of opportunities to be seen for residents, adult jury-eligible residents in Miami-Dade County?
2.
Let's go to the next slide. What does this represent?
That's the volume of media coverage by media type. Excuse me. This is where we simply break down the overall media coverage that we're analyzing for the client to see which media types were most predominant. This often comes into consideration when I'm looking at active versus passive media types. It can also be used to make inferences based on journalistic credibility versus media reporting. Just to elaborate, believe it or not, despite what we often see in political rhetoric, there are journalistic standards that professional journalists try to adhere to when reporting, as opposed to a person who might be creating media, a talk show, more of an opinion-based show, can have some greater latitude than a journalist might take with a story. But in this case, you can see TV news was the predominant, by far the predominant media type, followed by print media, with web and radio trailing behind.
Now, what is the purpose of this next slide, slide 4?
That is what I would call more of a control analysis, a simple control analysis to look at what would an average news story in the same area generate in terms of, say, impressions, or we look at several factors, total volume, how long it takes for that story to decay. Invariably, what it's going to show you is the attention, and the judge previously asked about engagement. There's a certain level of desensitization to the stories that are most common: car crashes, fires, things that we commonly see every day on the news. But we like to often look at what a average or common story statistically looks like compared to the story we're looking at for our client.
And so with this car crash story, I'm sorry, let me go back. How many opportunities to be seen or impressions? Hold on, trying to get to the right slide. There we go. Did you calculate for the average story?
But I'm having a hard time reading that. It's going to be the number of stories divided by the population, but I can't quite read what, I don't want to confirm what you're all seeing versus what I'm seeing.
Let me see if I can zoom in.
No, it's like trying to pass the vision test at the Department of Safety Motor Vehicle.
Your Honor, I failed the vision test. I was just kidding, that's not true. For the record.
Can you,
There was
I think it's getting a little bit bigger, Mr. Zell.
Yeah,
Is that better?
yes. Right, so this is going to demonstrate that this average story appeared in the media about the car crash. Let's see, six stories were reported on that topic, generating just over 935,000 opportunities to be seen. And I'm just reading at the bottom, the story appeared over a 3-day span in a population of nearly 160,000 residents based on census data. And then we apply, I believe either in Florida or Leon County, the jury eligible age is 18. And so we calculate only those over that age in our viewing population.
And so with that calculation, the jury eligible residents had 6 opportunities to see one of these stories based on.
That's correct.
Okay. And finally, with this exhibit, hold on, let's see. With this exhibit, what is the total number of juror eligible individuals according to census data in Miami-Dade County?
There's over 2 million in Miami-Dade.
Versus how many in Leon County?
Just under 160,000.
Before you continue, when you say census data, this is the 2020 census number that you're using as a part of
It
your...
would be the most recent census data.
Please continue.
I'm going to pull up Exhibit 3. I'll try to make it bigger for you. What does this exhibit represent?
So this is a timeline of media coverage, a quantitative count of stories over time. This is generally helpful in seeing the peaks and valleys. We can also easily interpret the decay of a story. So moving from left to right, in 2014, you see there's an additional starting point of the data, which then decays over the year to a low in 2015, and then spikes again during the year of 2016. Oftentimes you can correlate those spikes to activity around the subject. In a case like this, it can be arrests allegations, people being named, court hearings, but the spikes almost invariably will always indicate some activity around a specific topic. And then on the right side, you can see between the years of 2021 and 2025, a more rounded, but increasing volume of media coverage on this topic, which would indicate there are more things happening, more things happening of interest to the media, and a slower decay where follow-up stories are occurring during that date range.
What does this next slide represent?
That's going to represent the impressions of the media, I'm sorry, the impressions the media are generating for that same time period. The scales are going to be different, so the peaks are still there, and so you can see the 2016 and the 2019 peaks, and then you also see that kind of 2021 things start moving up, and then that more rounded curve from the prior slide, you can see how it's represented by the impressions of the media covering that subject. How many people it's potentially reaching.
Okay, and according to the analysis that TrueScope has conducted, can you tell the court what 2025 is 2025 projected to be higher or lower than 2024?
Yes. Impressions from media coverage for 2025 are on track at this point to surpass 2024.
Now, what do we have here in slide 4?
So this would be another control comparison, impressions of volume of coverage to another recent change of venue hearing or case based on what data is currently publicly available. So it indicates media exposure within Idaho compared to Florida. And it's and what it is specifically is a heat map of each state showing the density of media coverage in various counties.
And with and so this is what time frame was this analysis done, Darren?
This was just a one-year sample where we had overlapping data collected. Since we also did this work, this is overlapping data using the same methodology and framework from a case in Idaho, where we also had the same type of overlapping data from the Florida case.
What is represented in this slide?
That's going to be the same date range comparing two counties in Florida. The blue line would be volume of stories in Leon County versus volume of stories in Miami-Dade.
And how many, what was the volume of story? And again, this is that same one-year time frame, June of 23 to May of 24. What was the volume of stories in Leon County?
283.
And what was the volume of stories in Miami-Dade County?
It was about exactly 60 less, 223.
What does this next slide represent?
It's going to be similar date range in county comparison, but showing the impressions, the total tally of audience. And it's showing that in blue, Leon County had more impressions within that geographic area versus the number of impressions in the Miami-Dade geographic area.
What does this next slide represent?
Again, this is going to be a media type donut graph of volume of coverage by media type, which is going to indicate, for me, passive and active media. It also, to anyone who's viewing it, reveals which media was more engaged or reported more frequently on this topic.
I want to go back. Let's see. Now, over the lifespan of this investigation, July of 2014 to present, based on your analysis, do you have an opinion on how the span of time has impacted the media coverage in the case?
Yeah, I can certainly provide my opinion. In my experience, it shows a topic of interest to the media where the story has what, you may have heard the phrase, the story has legs. It has captured the interest of the media over time. Some stories, such as a car crash, at this point in time, it would be nearly impossible to find anyone in a county where a car crash occurred that could remember any details of that story. This is indicating repetition over time and volume of impressions are over time are high. So what I would start thinking is I expect to see in the numbers a higher level of retention based on saturation of an average citizen in a geographic area. So this is, in my work, this is what I start looking at and building what my expectation should be coming in the downstream data. And if I don't see it, then I have them rerun it to see if we made a mistake anywhere, or if there's a contributing factor to why a story stopped. But this is to summarize, this is a very typical shape and volume of impressions for a story that captures the interest of the media over time, at a high level, too.
And so I think that's a good segue into the math of memory that we discussed earlier. Can you explain to the court the concept of math of memory?
I hope everyone's had their coffee. So the math of memory is a basic probability theory that also uses a level of algebra, and it shows the ability to retain information, or inversely, how rapidly your memory of an incident or a story, in this case, decays over time. Ultimately, this formula is going to it shows, it's proven, and it's a globally accepted theory, that it has repeatable and valid results. The more a person is estimated to be exposed to a story, the longer they'll retain up to 80% of the details of a story.
The person you're referring to with this is someone of average intellect with no defects.
Right. It's when we say jury eligible population, that doesn't account for anyone who might be exempted for a reason other than age.
Please continue.
So how does the math of memory And I'm sorry, Mr. Murphy, were you done with the initial explanation of the concept of math of memory?
Yes.
Okay. And so how does, when you have, number of impressions and opportunities to be seen, how does that factor into the ability of somebody to retain that information?
In my mind, it's fascinating how logarithmically your potential to retain information goes up once you surpass seeing the story just a couple times. So what we do is we apply the number of, so we take the total number of media mentions or articles or stories, the coverage, divided into the jury eligible pool to derive the total number of opportunities for this story to be seen by a jury eligible person in that county. Then we can put that number into this formula and estimate statistically, I might say, I need to preface that with statistically, how long the average person of average intellect could retain up to 80% of detail on a story. How many, in terms of years.
Okay, and based on training experience, and when somebody has 376 opportunities to see an article or broadcast or podcast, how long do they retain that information?
If it's 336 exposures, I can't even estimate. I'd have to run the math again. And I can tell you, for example, if a person's exposed once, that retention to interpret the story would be 3.3 minutes. And I've provided, I think you have that chart up as I provided it. You can see how it extends once you get up above 10. Statistically, it exceeds the lifetime of a human.
So, breaking this down, with the opportunities to be seen that we have in this case, for an individual jury eligible of average intellect, they're going to be able to retain that information for their entire life.
Yes. And that's based on the resultant figure that in Leon County, the average jury eligible person was exposed 26 times.
Just a moment, Your Honor.
Go ahead.
Mr. Murphy, going back to the data that you were able to collect, you had mentioned earlier that TrueScope has the ability to collect and analyze podcast information and social media. Were you able to do that in this case?
To my knowledge, no. We were not able to include podcasts specifically in this analysis.
And why? And can you tell the court why that is?
There's two functional reasons. One, having access to the podcasts and retaining that data, we need to have a client engaged. If we don't have a client engaged, we're generally, well, let me start over. When we engage a client, we're tracking and going forward in most cases. With some media types, we retain that content and we can do back searching. In the case of podcasts, it's a newer medium. We don't have the ability to do back searching into the same time frame with podcasts. So I believe that was at least one reason why we excluded it from the data.
And what about social media? Were you able to include looking backwards at social media?
Similar situation. Social media requires that we register topics, and that's an internal phrase where we, in a sense, put the topic into the social network of, let's say, Instagram, for example, so that it can return results related to that topic through the API that connects us. Since we didn't have the engagement with your law firm in 2011, none of that had been registered, so we statistically excluded that media type. One reason. That would be my primary reason.
Just a moment, Your Honor. So, Mr. Murphy, since TrueScope was not able, TrueScope in this case was retained in January of 2025, correct?
Correct.
And so what you're saying about the social media and podcasts is because you weren't retained, you weren't able to go back in time to collect the data from social media and podcasts.
That is correct. Go ahead. I'm sorry.
If you had been able to obtain that information, are you able to offer an opinion as to how that would have impacted your conclusions about total number of potential impressions, or as the court was asking earlier, about active engagement?
Yeah, so there's a couple specific, I would say, factual opinions I can share. One, neither of those media types are able to be geographically pinned down. A podcast can occur anywhere, but be specific to another region. So it makes assigning it to a geographic region nearly impossible in most cases. So that's one reason. And I apologize. Can you repeat the question, because I got too deep into my first answer.
So I was asking how, if you could offer any conclusions as to how, if you'd been able to obtain that information, how it would factor into your ultimate conclusions.
So the geographic issue is one. What it would have done is it would have simply increased the volume across the board. It would have been treated more like national media exposure. And let's just use a simple number of 100, let's say. If there were 100 podcasts, it has equal potential to be seen in any of these counties or heard, as the case may be. And social media is the same way. It would have an equal opportunity to be seen in any county, not in Florida, but globally. So statistically, it would simply increase the values across the board by the same number. You would apply an N factor to it, and it wouldn't change the charting of impact or opportunities to be seen. It would increase the opportunities to be seen in each county, but by an equal amount, so the outcome wouldn't change, if that makes sense. And I can rephrase that if it was confusing.
I understood what you meant. I don't know if the judge would like a different explanation.
Make it as simple as possible.
Can you?
The water would rise equally in every county, and so it would provide no one an additional bump or decrease over another. It would just be a wash.
So in other words, if you had been able to factor in data from podcasts and social media, the numbers, whatever that number is, would have applied equally for Leon County and Miami-Dade County.
Right, it wouldn't change the outcome of the analysis. It would simply increase the numbers for all of them equally.
Nothing further, Your Honor.
Cross-examination. Does that microphone work?
I think so, Judge.
I can hear him.
Go ahead.
Mr. Murphy, can you explain your fee schedule associated with your work on this case?
I would have to check with my accounting. Our CFO would have that detail. We generally, I can speak generally to our fee schedule. There's a monthly subscription cost for us to monitor the data. And then in addition to that, if a client takes the opportunity to have us analyze their data, there's an additional fee for media analysis. So in this case, there would be two components, the media monitoring and the media analysis. And then on top of that, if myself or one of our team members is asked to provide testimony like this, there's an additional fee for my time or Cheryl's time.
Okay, can you give us a ballpark for what the cost would be for work that what you've done so far on this case?
Sure, a normal subscription to a monthly subscription for this type, and if I'm charging the client more, I hope that's not the case, but it generally runs around $1,500 a month for media monitoring. Analysis can often add another $1,000 or $1,500 a month to that cost. And then my fee, if I'm in person on site, it includes travel expenses, and then if it's just a one-day engagement, $10,000. If it's a virtual situation like this, my fee is $4,000.
Okay. Do you know how many potential jurors have actually viewed content related to this case?
No one can know that number for certain. So I think what we're looking at is possibility. Your question revolves around possibility versus probability. We're working with probability and statistics. When you want to say, I'm sorry, I answered your question. I won't go further until you ask me.
So the answer is no, we don't know how many potential jurors have actually viewed. We're basing it on averages and probabilities.
Correct.
Okay, and so is there a way that we could find out if an individual potential juror had viewed content related to this case?
I believe that's part of what would be done in the jury selection.
And could we also ask the juror, how long did you view the item? How much of it did you retain? Questions like that could be asked at jury selection, is that right?
Yeah, any questions could be asked. Then we get into the psychology, the behavioral psychology side from my perspective. What's the probability? And in my case, I'll only be speaking to probability because space jump could fall on the courthouse and change everything. So I don't deal in possibilities, but the probability is what we presented in the numbers. I'll leave it at that.
Okay. Do you have any data or probabilities about what percentage of potential jurors have formed a fixed or definite opinion about the guilt or innocence of this defendant?
That's a complex question, which I would not have.
In your affidavit that you provided to the court in this case, 3 prior hearings were cited. I know you said 4 previous hearings you've testified in, I think. Is that right?
Including this one.
Okay. So 3 prior, and how many of those hearings was the change of venue granted?
In the 2 earliest ones, those, I believe, one was moved from Sarpy County to Douglas County. That was in the 90s, I believe. I think so, different circumstances impacted, I'll call it the boyfriend-girlfriend murder. I believe the evidence was overwhelming and a deal was made before it went to trial or something. So I'd have to look back on that. In the most recent case, which is just about 10 months ago, that venue was changed.
So in the Catenacci murder cited in paragraph 14 of the defendant's motion, that case resulted in a plea, right?
That's my recollection. I don't have that information in front of me at this point.
So that venue motion was not ruled upon because the case resolved. Does that sound right?
That's my recollection.
Okay, and in Nebraska v. Christopher Edwards cited in paragraph 15 of the defendant's motion, that motion for venue change was actually denied. Isn't that correct?
That is correct.
Okay, and so we're just dealing with the Idaho case. Is that the case that we're probably all familiar with, where 4 college students were slain back in 2022, I think?
Yeah, that's the most recent one. But there's a little bit of an apples to oranges in the one where the venue wasn't changed. I was only asked to present on a report of media coverage. It wasn't a statistical analysis like this at this depth.
Okay, and in the Idaho case where the venue was changed, is that the same jurisdiction that's mentioned in your data compared to the data you prepared in our case?
I apologize, I don't quite understand the question.
When we see the map of Idaho in
Yes.
the exhibits that we just reviewed, is that referring to that case that occurred in Moscow, Idaho at the University of Idaho?
That is correct.
Okay, and in that case, the judge did change the venue to Boise, correct?
Correct. Ada County.
And would you agree that the population in that county of Idaho where the case occurred was significantly smaller than the population we have here in Tallahassee?
That is correct.
Okay, and in fact, in the motion that the court granted the venue change in that case, the court cited insufficient space in the courthouse, insufficient staff, and insufficient security.
This is outside the scope.
May I finish my question before there's an objection, Judge?
Please finish your question.
In that case, isn't it true that the judge, in granting the motion for the venue change, cited insufficient space in the courthouse, insufficient staff, and insufficient security, AKA deputies, to accommodate the trial of that case?
What is your objection?
Outside the scope.
It's in his
I believe part of his
affidavit,
testimony
Judge.
has been concerning his work in Idaho, is it not?
Yes, Your Honor, but we did not get into whether or not the venue motion in that case had been granted or the reasons for that in his testimony or in his affidavit.
As to the subject matter, I will permit the question. If you are capable of answering the question, Mr. Murphy, please do so if you have knowledge.
I can only answer to the portion I have knowledge on, and I believe it was cited that the testimony of the media exposure was also a contributing factor, but I'm not an attorney.
Yeah, I think you're right about that. My question is, there were other factors in play. You may know that or you may not. Are you aware of that?
It's outside of my purview and role in this case.
That's not my question. My question is, do you know that that was in the order or not?
I will say no.
Okay. And we have had related cases related to this case tried here in Tallahassee. Are you aware of that?
I would assume you've tried cases in Tallahassee.
But co-defendants related to this case that we're here about have been tried here in Tallahassee. Are you aware of that?
I am.
Okay, thank you. In the spreadsheet, this was one, I think it was in Exhibit 1, Tab 1, where Donna Adelson and Charlie Adelson appearances in the media are lumped together. Are you familiar with what I'm referencing?
Is it the spreadsheet?
Yes.
Yeah.
Why were Donna Adelson and Charlie Adelson lumped together for purposes of that presentation?
I would have to speak with the client and the media monitoring team to see why that query was built that way. That would be my answer.
Were the numbers ever run for Donna Adelson alone?
I'm sure they were. In the course of testing queries, we run them many different ways. Ultimately, we arrive at a query that best captures the media exposure specific to what the parameters are around the case our client has asked us to be engaged on.
Okay, so I think that kind of gets to my next question. Who made the decision to lump Charlie in with Donna in the data included on Defense Exhibit 1?
I would say, I don't know. It would be a collaborative discussion between the client and our analysis team and our search strategist.
Okay, but ultimately, if you have data for Donna alone and data for Charlie and Donna together, who's going to decide what shows up in Defense Exhibit 1? You or the client?
It's going to be a combination. We would probably offer a recommendation since in these cases, either name is probably not in the news for another issue. And we often will search to see if, I'll say, John Smith, if he's involved with a case as a alleged conspirator or whatever, also has a car dealership that frequently advertises that mentions his name. We'll check to see if there's other contributing stories. If there's not, then we'll make a determination that if it would be statistically impossible to mention Donna Adelson without mentioning Charlie Adelson, we'll run the names together because the query is functionally one subject. Now, if either party in that query starts to exhibit a volume of content on their own and not in relation to the other party, we would separate that and at least counsel our client that we should run this separately.
Okay, so are you able to tell the court how many of those articles that represent Donna and Charlie together, in how many of those does Charlie's name only appear in without Donna? So I'm not really after, I asked the question incorrectly, let me start over. I asked how many for Donna alone, but what I'm really interested in is how many does Donna's name appear in, period?
That would be done with you could do a simple search in the spreadsheet and search not for a name, Charlie, or only for Donna. and see how many of those 2,000 plus stories only mention one name.
Is that something you could do for us right now, or that's something that takes time and analysis to perform?
It would take, I wouldn't want to do it live on TV. I want to make sure we followed our methodology and protocol and have two sets of eyes check it.
All right, so you don't have that data to provide to us right now as far as how many does Donna's name appear in?
The data's there, we would just have to, or someone on your side or another could sort it.
Okay. When you're talking about opportunities to see a particular article or content, does that presume that all Leon residents actually have the same likelihood of seeing the content?
They all have an equal probability of being able to see the content.
Okay, but actual views could be consumed repeatedly by one viewer and not at all by another, correct?
That's a possibility.
All right, so if you're saying I had 376 opportunities to see this content, it's possible that I, as an individual, could have actually not seen any of it.
That is a possibility.
And it's 376 total opportunities over how many years?
I believe about 11.
Okay. And so I think in your math of memory, we can agree that the passage of time in general does not serve our memory well. Can we agree with that?
That is true.
Okay. So I would need to ask a particular juror, how long ago did you see the content and how much do you remember from the content to really know what that juror remembers, right?
To know what an individual knows or can reveal, that would be correct.
How many opportunities does the average person, adult, have in an average day to have an impression from any content? And I guess I'm thinking of, waking up, picking up my phone, scrolling this morning, turning on the news, riding to work, listening to a streaming service on the way to work. I've already been bombarded with a bunch of opportunities, haven't I? Just today.
I would need to know where you live.
Okay, but in general, let's just take the folks in this room that are sitting in here now. Like, we've already had a lot of opportunities to observe content. Would you agree?
I would think so. I don't know you, so I don't know what your propensity to consume news is.
But you deal in averages, and you're telling us what the average adult has the opportunity to consume based on that data.
Right. So I think if you look at the control story for a car crash, that would give you your answer. I think it was 6 opportunities to be seen, or 4, something like that.
Right, but we're bombarded with this stuff all day, every day, is my point.
I don't see relevance to the question for me.
Okay. All right, so can we agree that actual memories of an individual vary? I mean, again, going back to what you were saying about I'm dealing with averages and probabilities, an individual might have differences based on their actual exposure to the content, based on their actual ability to retain information, based on their interest in the topic, based on what else is going on in their lives, their age, and lots of other factors. Would you agree with that?
I would.
You said the average person, the average Leon juror has been exposed, or at least had the opportunity to view material about this case 26 times. Is that right? Did I get that right?
That is correct.
Okay. And do we know how many of those 26 contain the name Donna Adelson?
All 26 stories would contain the search term. So these are 26 opportunities to see the specific story about, I believe in this case, Donna Adelson.
Okay, but it's got Charlie lumped in with it, doesn't it?
Right,
Okay.
yes.
And based on those 26 opportunities, you talked about the math of memory and how after a certain number of exposures, a person is likely to retain some, I guess, some of that information up to the rest of their life. Are you able to tell us what information is likely to be retained by a juror who's had these 26 exposures?
Yeah, it's the test on the model is can recall 80% of the details.
Okay. And so would it surprise you to learn that previously when we've asked jurors about this case, we get about a third that don't know anything, a third that know the headlines, and a third that have more detailed information? Does that comport with your work, or does that seem inconsistent with your work?
I'm unfamiliar with your procedure for selecting a jury.
Okay, but based on your analysis, does that sound about right, that that's what we would expect, or would you expect something different?
I can't, it's outside of my area of expertise. Jury selection, I don't do.
But you're saying they would retain 80% of the information if they had been exposed 26 times. Is that what you're saying?
Yeah, I'm saying the probability of an average person in your county, I believe you're in Leon County, that would be the probability of an average person of jury selection age.
The probability of the average person of jury selection age who was in fact exposed 26 times retaining 80% of the information.
Have the opportunity to be exposed 26 times.
Okay. But they definitely have to actually be exposed to get any of the retention that we're talking about.
That is true.
Then we can't know that unless we ask them.
Knowing, yeah, I guess I can't. My work is in the probability of people before they enter your room. So all I can speak to is the probability of the people you might encounter during a jury selection process. I can't answer a question about who you will encounter during a jury selection process.
Right. Understood. No further questions.
I have a follow-up question, and from there, the parties can follow up as they need to. Mr. Murphy, I remember when you were testifying on direct that you were stating your numbers as it relates to the probabilities rely on the taking of the last census, correct?
Yes.
In any way, do these numbers account for seasonal fluctuations or shifts?
In terms of immigrant labor or?
Well, let me be more specific. Here in Leon County, we have 3 colleges and universities, meaning when you have a freshman class coming in each year, there are now 18-year-olds who will meet, presumably, juror eligibility. In that way, for that fluctuation of persons who may be eligible jurors by statute, does your data take that into account in any way?
I can't answer that without asking a question related to your fluctuating population. If you would like me to ask that question, I can, Your Honor.
You can ask, I'm not sure if I can give you much more, but go ahead.
So, in the case of students, I have two children who have gone through college. Do they need to be registered voters? I don't know what the statute says.
They would have to have a driver's license that has a residency for this county. That would be at least the initial pull for coming into the juror pool.
So we would have to look at, let's say you have 20,000 students that fluctuate at the university level. How many of those have a Florida license and a valid Florida license, and how many do not? You can probably get that statistic directly from the university of how many outstate students attend each year.
Very well. And would this impact what your numbers and analysis are?
Probably probably at a very marginal level. Once you removed the out-of-state students and those who don't drive, then you're going to be left, if we started with 20,000 and removed those who aren't registered with a valid driver's license, the number would get down to a small enough number where it may impact the population of jury-eligible students by maybe 10,000. A small number that statistically wouldn't shift this, maybe by a percentage, but nothing more.
And I believe also you stated as well, you made a comparison of your data to Nielsen ratings.
Yes.
How closely would you say that mirrors? And the reason I ask this is because a Nielsen rating or maybe a radio rating, I think the science behind it, they've tried to make it as detailed as possible because they're trying to use that information to monetize it, correct?
Correct.
But ultimately, even with a rating of that nature, when, say, it's reported there were 200 million people that watched the Super Bowl, that doesn't tell us, did you watch every snap? Did you turn it off at halftime? Did you turn it on in the fourth quarter because it was a good game? It can't really drill down. It's just ultimately, this is the big number that watched the game.
Right, on the gross number, that's correct. But when you're starting to get into the engagement level of the activity or the action within the media, so statistically you can measure that people are more probable to watch a tight Super Bowl game that goes into overtime. The eyeballs on that overtime are going to be higher than maybe the middle of the third quarter. So you can show some statistics around topics or activity within the content, and that's what you would see in the numbers presented as evidence of a car crash versus, say, a murder. Murders are always going to gain a higher probability of attention, are going to have a higher probability of attention than the topics we're desensitized to, like a fire, a car crash, a fender bender, a robbery, things that we see and hear every day and don't engage with because psychological behavior, we desensitize ourselves to those topics.
Very well. Any follow-ups by the state to the court's questions?
No, Your Honor.
Mr. Zellman, you may redirect us to all topics, including the court's questions.
Thank you, Your Honor. share my screen again, Mr. Murphy. On cross-examination, the state asked you about the 26 opportunities to be seen. To be clear, Exhibit 3, during what time period did those 26 opportunities to be seen take place?
If I refer to the chart,
Let me actually share my screen.
thank you.
Sorry.
So this is, what the slide that you're showing now is the 1 year sample for comparison.
And so with the full set of data, that is identified in Exhibit 2,
Excuse me.
You can zoom in for the witness, Mr. Zellman, so you can see it clearly.
Thank you, Your Honor.
Well, not giving you the vision test again. Go ahead.
now the time period that is indicated in Exhibit 2 with 376 opportunities to be seen per person, what is that time period?
So that's July 2014 to January 2025. That would constitute what we know as the first story, The first story we sometimes either call the alpha clip, the alpha story, or the breaking news story. It should constitute that through the cutoff date in January of 2025. In order to do an analysis, we have to have a specific starting and a specific end.
So during that roughly 10 and a half year period, there were 376 opportunities to be seen
In Leon County,
in Leon County. And then
per person.
And since then, since January, that number has remained constant or has it increased?
If there's been any media coverage, which we know there has been, then that number has gone up. But since we are presenting that in the analysis, I won't speak to how much. But I stated earlier, we are on track to exceed 2024 total opportunities to be seen based on media coverage and impressions.
Let me go back to that exhibit.
And when I say we, I'm referring to the media monitoring side of TrueScope.
So going back to that slide on Exhibit 3, this is where you're indicating that 2025 is on track to exceed 2024.
Correct.
And so 2024 had over 92 million media impressions, correct?
Right. And that would speak to the fact that each individual of jury-eligible age, that would speak to each person in that designated market area, in this case, the entire state of Florida, has the capability, and as the prosecution pointed out, a person can consume more than one story. And as the model for memory shows, each time you see another mention, you have the potential to strengthen your knowledge on the details of the story.
And slide 2 of Exhibit 3, you indicated in your direct testimony that this represented, there were some peaks and valleys when the volume of coverage was greater or lesser. So if I were to tell you that the initial arrest took place in 2016, would that correlate with the data where there was a significant increase in the number of stories?
Yeah, we would look through that number to make sure you are correct, but that fact that you state is, or would be indicated by that peak.
And the same, in 2019 was the initial trial. Would that also correlate with the peak in the data that's identified in exhibit, slide?
Yes,
Exhibit.
anytime there's an element to a long-running topic in the media of significance, you'll see a peak like that.
And so is it fair to say that the length of time, or when key events happen such as trials, the media coverage increases?
Yes. And that's a simple function of the media. They want eyeballs, and they know what stories have interest to the community they serve, or may not have an interest to the community they serve.
Just a moment, Your Honor.
Go ahead.
One last question, Mr. Murphy. Based on the analysis of the data that was collected in this case, is it fair to say that the overwhelming number of publications and broadcasts took place or were presented in Leon County?
Could you say that one more time, please?
Sure, sorry. Based on the analysis of the data that was conducted in this case, would you agree that the overwhelming number of publications and broadcasts concerning the story took place in Leon County, Florida?
That is correct, yes.
And that, statistically speaking, Miami-Dade County, with a significantly greater population, has a significantly less media exposure in this case.
That is true.
Nothing further.
Mr. Murphy, that concludes your testimony during this hearing. You may remain on the Zoom if you desire to do so. I am now going to speak with the attorneys as to their arguments on the law or any other evidence if they have to present it.
Thank you, Your Honor. Is it standard operating procedure that I would remain, or do people normally exit?
You can exit or you can stay. It is up to you, but you are free to go.
Okay. If I'm needed further, please let me know.
I'll call you.
Thank you, Your Honor.
Mr. Zellman, any other witnesses or evidence that you wish to present?
Your Honor, can we have a 5-minute recess, please?
That's fine. I will stop the clock during the recess.
Well, thank you.
5-minute break. We'll go to about 10:50.
Thank you very much, Your Honor.
defense have any other witnesses or testimony as a part of the presentation?
No, Your Honor.
Very well. State, you may make your rebuttal presentation if you have one.
Judge, all I have is a thumb drive that I prepared as State's Exhibit 1. I intended for it to contain the 3 prior jury selection transcripts on the related cases, but for some reason we weren't able to find the first one, so it contains the most recent 2 transcripts of jury selections conducted in the related cases, co-defendant cases. I'd like to admit that for your consideration.
Is there any objection from the defense?
I don't think there's a legal objection to that, Your Honor.
States 1 as the thumb drive is admitted as well.
That's
Any
it,
other
Judge.
evidence or presentation?
Just argument, Judge.
You may make your argument, Mr. Zellman.
Thank you, Your Honor. Your Honor, as you're familiar with my practice, I tend to put it all on paper, and I did that in this case. I do want to highlight a number of items, though, Your Honor. In Exhibit 5 is listing of the podcasts. 77 pages long of individual podcasts. There is some overlap between platforms. However, it's not just the podcasts that we're asking the court to consider, but also what people are saying during those podcasts. The effect on the listener that those podcasts have and the comments that the public makes are where we are seeing the most significant prejudice. The vitriol towards Mrs. Adelson, to her son, to her daughter, and we also see in those a number of podcasts. I ran a search yesterday. I counted over 20 different episodes just focused on inadmissible information. As Your Honor is aware, prior counsel in the state, you had an in-camera hearing last September. I'm not going to go into detail about what was contained in that. Unfortunately, back in December, when Your Honor authorized that to be transcribed, it was not sealed when it was posted to the clerk's website. Media outlets from all over the country obtained that information. They obtained the transcripts, they published the transcripts in full, they analyzed them in their podcasts, so now what Your Honor has ruled to be inadmissible is out there. It's out there for and as I said in my motion, you can't unring that bell. One of the factors is whether the publicity has included information that would be inadmissible at trial. In addition to that inadmissible information, we still don't yet know which audio recordings the state intends to seek to admit in the trial. However, there are audio recordings that we submit would not be admissible against Mrs. Adelson. It's our position, Your Honor, that co-conspirator exception, the conspiracy ended when the murder took place. Conspiracy did not continue to extend beyond that. As a result, any of the statements that were made in 2016 on the wire by other individuals, other than Mrs. Adelson, are not included under the co-conspirator exception. And those would be...
We would have to, I think, handle this through a separate motion in limine or argument as to that hearing, but as to the completion of the murder being one part of it, yes. As the conspiracy being ongoing for the conspirators never to reveal what their role is, does that ever end, Mr. Zellman?
I'm sorry, what was the last part?
For the persons who may have participated in the conspiracy, would that not always be an ongoing thing, so their role is never revealed?
The way that this is charged, Your Honor, I would say no. It's charged with conspiracy to commit a murder, not conspiracy to cover up a murder.
Very well, please continue.
So you have, it is our position, inadmissible information that has been publicized. And it's nobody's fault for the vast majority of that information. This case has been tried 3 times. Each trial has been live streamed. All of the testimony has been publicized. So as to what could have been done prior to our involvement on behalf of Mrs. Adelson, all of that evidence was already out there. And it's our position, Your Honor, that with respect to those statements that are not admissible as to Mrs. Adelson, and to back up, Your Honor, once the state identifies which wire recordings they intend to use, we certainly will file a motion in limine and ask for a pretrial ruling, so we're not dealing with that during trial and potentially wasting the jury's time. But we can't do that just yet, because we have to wait for them to identify the calls.
And you're referring to the most recent wiretap or the wiretap from 2016?
Both.
Very well.
Another factor that Manning tells us to consider is the Preston Oates tell us the timing of publicity relative to the incident and the trial. So historically, courts have said, okay, well, we're going to continue this trial a year, 18 months, 2 years, so that the original publicity has died down and that won't factor into potential jurors' minds. That's not something that exists in this case. As exhibit, let's see, I believe it's exhibit 3. Indicates the publicity that has taken place in this case has not died down. There's been an ebb and flow over the years. So initially in 2014, there was, obviously that's when it first happened, there was significant coverage. That died in 2015 during the investigation, and then in 2016, once the arrests were started, the initial plea by Mr. Rivera was entered, and Ms. McBanner was arrested, there was a great deal of volume of coverage. 2017 and 2018, it died down. 2019, the first trial, it increased significantly. And then in 2020, 2021, it died down. 2022, during Ms. McBanner's second trial. 23 for Mr. Adelson, Charlie Adelson's trial. 2024, 2025, all of those increased. And as Mr. Murphy indicated in his testimony and in Exhibit 3, specifically slide number 3 of that exhibit, the media coverage in 2025 is on track to suppress last year's totals. Last year's media impressions exceeded 92 million. So it tells us that the timing of publicity, it's not going to die down. It's going to continue to circle. I mean, we're sitting here, we have reporters typing behind us. This hearing is probably being broadcast live. And so that weighs in favor of granting the motion.
Do the defense filings or filings by the state in particular play any role in those?
I'm sorry?
Do the defense filings or filings by the state with the pleadings play any role in those?
I don't know that I can answer that. It's one of the reasons I think that we had filed the materials in support of this motion under seal, so that the information was not highlighted again for the media. We obviously, court records are public with limited exceptions. So I don't know how that factors into it.
Very well. You may continue.
With respect to all of the podcasts that have been identified in Defense Exhibit 5, as well as any commentary that is contained within those podcasts that members of the public are able to provide their own insight on. Your Honor, reviewing that information becomes clear that the community's hostility towards the defendant is overwhelming. The sentiment from all of those podcasts, not necessarily the hosts of those podcasts, but for a vast majority of them, yes, for the hosts, but for the people who comment on those podcasts, the vast majority of it exhibits hostility towards the defendant. And in almost every single one of them where you have the talking heads offering their opinions, the vast majority of them offer their opinions about Mrs. Adelson's guilt or innocence and are publicizing it, and the vast majority are saying that she is guilty, and they are skewing the reporting in a way to support their theories. All of that's in evidence, Your Honor. I'm asking the court to consider that in reviewing the factors that the court is supposed to consider. And I want to highlight, Your Honor, before I wrap that up, actually, there is another factor that needs to be taken into consideration, and that's when a confession is featured in news media coverage of a prosecution. Confession of Mr. Rivera and Catherine McBanowa has not only been published, but their testimony has been broadcast on live television, summarized in local print news media, as well as the podcasts. Now, I recognize...
Let's break them down as individuals, because with Mr. Rivera, I believe his testimony has always been that he went and did a murder for hire as a paid job. He did not know who essentially the principal was, but it was organized through his friend's girlfriend.
Correct.
In that way, how exactly is that a confession that implicates your client?
Well, I'm trying to find that part here. Let's see. I guess, Your Honor, Mr. Rivera is not as significant a factor as the testimony of Ms. McBanowa. Her testimony in Mr. Adelson's trial, her proffers, transcripts of which have all been released to the public, and the recordings of which I presume have all been released to the public, detail her recitation of what happened and directly tie into Mrs. Adelson's alleged involvement in this this murder. So now I recognize that factor comes from Oliver. As I indicated in my memorandum, recognize that Oliver has been restricted and refined. In Hoy, one of the cases that restriction refines Oliver, the detective summary of the confession was published, as well as 3 contradictory statements made by the defendant. Here, no statement by Mrs. Adelson has been published except for the statement that was released, I believe, back in 2016 by her then attorneys, denying any involvement. However,
That was a statement she made, or just that the attorneys made in response to a press release?
it was a press release from her attorneys.
Directly quoting her, or just
No.
on behalf of the family in general?
Is on behalf of the family. That's the only thing, I believe, that has been published on behalf of Mrs. Adelson. But it's not a statement directly from her.
Please continue.
So you have the confession as another factor there. And what I want to say, Your Honor, is quoting from Singer versus State, the Florida Supreme Court said, every trial court in considering a motion for change of venue must liberally resolve in favor of the defendant any doubt as the ability of the state to furnish a defendant a trial by a fair and impartial jury. Every reasonable precaution should be taken to preserve to a defendant trial by such a jury, and to this end, if there is a reasonable basis shown for a change of venue, a motion therefore properly made should be granted. A change of venue may sometimes inconvenience the state, yet we can see no way in which it can cause any real damage to it. On the other hand, granting a change of venue in a questionable case is certain to eliminate a possible error and to eliminate a costly retrial if it is determined that the venue should have been changed. Your Honor, it's our position that although a jury has been seated previously, media coverage, and again, when I'm saying media coverage, I'm referring not just to print and broadcast, but also to the podcasts that are in evidence, overwhelmingly points to the fact that seating a fair and impartial jury in this venue is going to be impossible, and in order to avoid the expense associated with making that attempt, the court should now grant the motion for change of venue.
As to both Singer and the cases that follow it, does this argument account for the most recent Florida Supreme Court precedent on this topic? The cases that go to not only must there be prejudicial media coverage, but there was an attempt to seat a jury and you could not seat one.
Your Honor, it's our position that the case law is still valid. I'm not sure exactly which case Your Honor is referring to. I'd be happy to look at it.
Smith versus State, 320 Southern 3rd 20. Case from 2021.
I'm sorry, Your Honor, you said it was 320 Southern
3rd 20. Donald Smith versus State of Florida, and deals with, this is a death penalty appeal, but deals with change of venue along with other issues. Cites to Griffin versus State and Rawling versus State, and deals with the issue of pretrial publicity.
Can I have a moment to review that, Your Honor?
Go ahead.
Your Honor, just briefly reviewing Smith and Griffin, both involved in analysis of fundamental error. In both cases, trial counsel did not obtain definitive rulings. One of them, I believe in Griffin, Your Honor, trial counsel didn't file a written motion, brought it up just before jury selection and didn't object when the veneer was sworn. Smith, same issue happened there. Smith attorneys did not renew their objection or request a final ruling on the motion for change of venue after the jury was selected. So those, I believe, are distinguishable from what we have here.
Ultimately, with that, we are not talking about an issue of review for fundamental error, as no review would even be ripe yet at this point. But as to the test that it lays out, in exercising discretion regarding a change of venue, a trial court must make a two-pronged analysis evaluating the extent and nature of any pretrial publicity and the difficulty encountered in actually selecting a jury. As to that, is that the applicable test that the court must use?
I would say that that applies when jury selection has been attempted, but my research indicates that no Florida Supreme Court case has overruled the test set forth in Singer that pretrial publicity on its own can still be a basis.
As a point of law, I don't believe your reading of Singer is wrong. However, these cases are refined over time. I believe Singer was 1959.
Yes, sir.
Cases that are almost as old as my father, they're still good, but they do change over time.
I agree, Your Honor, but it's the case law also cannot be overruled by implication. No higher court, no Florida Supreme Court case has said definitively that Singer is no longer good law.
Very well. State, you may provide your rebuttal argument.
Judge, what I learned from the defense expert is that there's been a lot of publicity in this case, which I think we all already knew, as is their right to report on a case that's been of high interest to this community, and that we have a high probability that we'll encounter some prospective jurors who know something about this case. Something I think we all already knew. What and how much and whether they formed a fixed or definite opinion are factors relevant only to those individuals and can only be learned at jury selection. Similarly, who has consumed inadmissible or discussions of inadmissible evidence? We can only learn that by asking them who's listened to these particular podcasts, and I trust that the defense will do that. I also expect that it will be relatively few. Maybe I'll be proven wrong, but again, the fairness that we're guaranteeing her of this trial is through that jury selection process, that those jurors will be asked those questions and that if appropriate, they will be stricken. To secure a change of venue, the defendant has the burden to show this court that there is a reasonable likelihood that prejudice against her in our community will prevent her from receiving a fair trial. How do we know if the facts or the media coverage of a case has prejudiced us such that the citizens of this community where this crime occurred are not capable of rendering a verdict based solely on the evidence that's presented in court, except in the most exceptional circumstances, which I can imagine, to answer your question about Smith versus Singer, I can imagine, maybe a George Floyd or a circumstance where the answer might be to avoid attempting to pick a jury because there's no point there. But this certainly isn't a case like that. The defendant in their own motion cite Lozano. Lozano is a third DCA opinion, not binding on this court, and distinguishable from our case. But according to Lozano, a change of venue is appropriate where legitimate community safety concerns might influence a jury's verdict. Lozano was a racially charged incident in which a Miami police officer shot and killed a motorcyclist and his passenger, whereby they then crashed into two other citizens, injuring them. And it sparked protests in that community immediately upon the incident occurring. There were riots in the Miami area which caused school closures. A 130-block area of the town was cordoned off for crowd control, and the use of tear gas was deployed against the members of that crowd by law enforcement. So in the Lozano opinion, The court said that a fair trial could not be conducted in an atmosphere in which the entire community was so obviously, penetrated by the feels that resulted from this incident, which was basically like a lightning rod in the community. And the
You
court
literally couldn't get through the courtroom door, essentially, to start the case.
Right. I mean, I can imagine a situation where you can't pick a jury under a situation like that, where the jurors are potentially concerned about their own safety or the safety of the community if they render a particular verdict over the other choice. Dan Markel's death was felt deeply by many in this community. I certainly would never argue the contrary, but it's distinguishable from an incident like Lozano, which involved a community reaction driven by underlying social, economic, political factors, widespread fears within the community, and is prone to sparking something like a violent outbreak. Nobody's going to start a riot based on Donna Adelson's verdict, whichever way it goes. Next, defendant cites Manning, a case in which there was a change of venue granted, but that cites McCaskill, where the test for venue was set forth, or the test for change of venue, I should say, but in which, in McCaskill, the motion for the change of venue was actually denied. And the court said a determination must be made as to whether the general state of mind of the inhabitants of the community is so infected by knowledge of the incident and the accompanying prejudice, bias, and preconceived opinions that the jurors could not possibly put these matters out of their mind and try the case solely on the evidence presented in the courtroom. What the defendant left off of that quotation in her motion was the sentence that preceded that quote that I just read, which states, "Knowledge of the incident, because of its notoriety, is not in and of itself grounds for a change of venue." All we've got right now is suspicion that several jurors were going to have knowledge of this incident. We have a case that's gotten a lot of media attention and has gained notoriety in our community. But to conclude that this case has rendered our entire citizenry incapable of giving Ms. Adelson a fair trial there's no evidence to support that. Manning was also a racially charged case involving the murder of two well-liked white deputies by a young black defendant in a small rural community. There were about 31,000 people in Columbia County in 1976 when the Manning case occurred. A voir dire inquiry in that case revealed that every member of the jury venire had significant knowledge about the crimes. That is not what I anticipate we'll have here. It's distinguishable from this case where we have successfully selected 3 prior juries on related cases under similar circumstances with similar media attention. And I would reference states 1 for that, which is the transcripts from trials 2 and 3.
Well, to that point, and I don't think the state is really disputing the mathematic analysis that has been provided by the expert, there has been a spike as the various trials have gone on, correct?
Sure, there's more content out there. I think some of the content is the same that's being hit over and over. And I think the problem with the analysis from the expert's perspective is that we're just going to divide all the content by all the people and spread it out evenly among all the people. And that's just not how the world works. Some people are going to pursue content. Some people aren't going to see it at all. Others are going to just look at headlines. Those people are still eligible to be jurors unless they formed a fixed or definite opinion about guilt or innocence based on those headlines. So to, divide all content by every eligible juror and say, oh, you've all got 376 exposures to this, you're all ineligible, is just fuzzy math.
So you're saying going from the general of what the math might be to the specific of if we take random person off the street, we still need to ask, what do you know, what have you heard?
I think so.
Please continue.
I think that would be appropriate in this circumstance. I'm not saying it would be necessary or required in all circumstances, but certainly here, where the media content, yes, there's a spike because something's going on, stuff is happening, but it's the same I think, going to turn out to be the same people consuming this stuff over and over and over again, and those people probably won't be eligible to be jurors. But as we've learned from experience, there's going to be a lot of people that are still eligible, and I think we should at least try before we take this case away from the county in which it occurred and move it elsewhere. Certainly, I can't imagine a planet on which we move this case to Miami, which seems to be suggested by the defense. I mentioned when I was cross-examining the expert who had no knowledge of this, but I think that State's Exhibit 1 will reflect that about a third in our individual voir dires on previous jury selections had no knowledge of this case, which might be surprising to some of the people in this room who are consuming it regularly, but not everybody consumes this stuff. And about a third had very limited knowledge. Those people are still mostly eligible to become jurors. And then there's a third that have more detailed knowledge, and some of them didn't have fixed opinions and were still eligible to become jurors in the case. So while many jurors were disqualified in those proceedings based on their knowledge and their feelings about the case, there were plenty that weren't. We picked a jury in 2 days on the first 2 trials and in 3 on the third. On the third trial, we had a defense jury expert flown in from Manhattan to drill down specifically on individual voir dire regarding publicity. And that was a time-consuming process, and we still were able to successfully get an unbiased jury that was agreeable to both sides in 3 business days.
I'll review your exhibit, but do you recall of the jury that was actually selected, what was the breakdown of no knowledge, some knowledge, or stated they would set their knowledge aside?
My recollection is that it was roughly a third, a third, a third. But,
And this is the most recent jury.
yes,
Go ahead.
I've just noticed that pattern both in voir dire, who we end up with, repeating itself throughout, my life that has become this trial. It's happening over and over again. So can I say specifically that what we ended up with was that breakdown? No. But that has been my observation over time, is like, gosh, there's a third of the community out here that still has never even heard of this thing. So I'm suspecting they're still out there. There has been a peak. Maybe we'll try and learn otherwise, and it won't be possible. I don't think that's going to happen, though, Judge. We were going to weed out the folks that are not eligible until we get down to a panel that's acceptable, and then we're going to proceed with other questioning. Since we've selected, 3 jurors previously, I don't think this recent spike in activity of media is going to somehow make it impossible to get a jury this 4th time. I did want to cite Copeland v. State. I have a copy for Your Honor and the defense if you'd like, but it's at 457 Southern 2nd, 10-12-1012, a Florida Supreme Court case from 1984, in which the court held that a widespread public knowledge about the case is not the focus of the inquiry on a motion for a venue change based on pretrial publicity. Rather, the critical factor is the extent of the prejudice. So what is the prejudice? Defense has really only pointed to these podcasts with opinions about guilt and inadmissible evidence being discussed to really talk about this hostility and this prejudice that's out there. And I think we need to ferret that out through the jury selection process to determine whether that has really infected the jury venire as a whole. I think we're going to find that it has not, and none of the expert testimony related to that. The court goes on to say in Copeland that if it is possible to impanel a jury that can be relied on to decide the case based upon the evidence and not be influenced by knowledge gained from sources outside the courtroom, then a denial of a change of venue is proper. Again, in Copeland, every member of the jury panel had read or heard something about the case, but because all of them said they could set aside that information and render a verdict based solely on the evidence presented in court, the motion for a change of venue was properly denied. I also want to draw your attention to Hanyard v. State, Hanyard, at 689 Southern 2nd, 239. So Supreme Court case, Florida Supreme Court, 1996. This was a death penalty case in which the court said that absent extreme or unusual situations, like what we saw in Lozano maybe, the need to change venue should not be determined until an attempt is made to select a jury. And this goes to the Smith case that Your Honor
brought up earlier. In Hanyard, again, all the prospective jurors had heard something about the case, but each agreed they had not formed a fixed opinion about guilt. Each agreed to consider only the evidence presented in trial in making a decision, and so the motion for a change of venue in that case was also properly denied. We have not yet attempted to select a jury, but we have every reason to think we can, should, as recommended by the Florida Supreme Court. Your Honor brought up Rawling v. State, and I highlighted that one as well, that outlines the two prongs. Prong number one, the extent and nature of the publicity. We do have extensive publicity, but I don't think we have sufficient evidence that the nature of it has been improper or inflammatory such to infect the jury venire as a whole. And the second prong, of course, is the difficulty encountered when actually selecting a jury. Again, we should, but have not yet tried to select a jury. And again, we have the benefit from the previous efforts to suggest that we will be successful in selecting a jury in this case. In page 3 of defendant's motion, she relies on Oliver for the proposition that published confessions should equal a venue change. Oliver was a case in which the Tallahassee Democrat published a summarized transcript of the defendant's confession before his trial. I think Your Honor got to this a little bit in your questioning of the defense, but Oliver's not applicable here because there is no confession here. If there's a confession of Donna Adelson, could someone please send it to me post haste? So hence the confession of Donna Adelson has not been published. They cite the testimony of co-defendants, Magbanua and Rivera, which one is not the same thing as publishing her confession as Oliver, as what happened in Oliver. And also neither of these witnesses really offer testimony tantamount to a confession, Donna Adelson, which I think Your Honor pointed out. In addition, it should be noted that the Oliver case happened in 1968. Another factor Your Honor mentioned in your questioning of the defense, several of their cases happened quite a long time ago. The population of Tallahassee, according to Google, not very official source, was 68,000 in 1968. And when I'm guessing that the Tallahassee Democrat, no offense to my friends, was probably reaching a higher percentage of the community than they do today because of how many options we have today, how much media is out there, and the ways it has to reach us through our phones and otherwise. Today, as evidenced by inquiries of hundreds of prospective jurors in the last 3 related trials, as evidenced on State 1, many jurors abstain from local media entirely, choosing to get news online or from national outlets, an option that was just not available in 1968, or they, some of them abstain from news entirely and say, I don't watch the news. All right, so all the analytics provided by the defense presume that all the prospective jurors have had equal opportunities to review these stories, and that's simply not the case. Not all prospective jurors consume media the same way. They don't all watch any media that has anything to do with this case, and they certainly don't all do it with the same amount of thought or attention. All of this is fair game for exploration at jury selection and should be attempted before taking this case out of Leon County. There is reference, I thought we'd get more into it with the expert. We really didn't get there, but in the motion there's some sort of, there's subliminal mind control that the media does on us, which we don't really know, we can't really report at jury selection, but we might be biased and not be able to spit it out at jury selection. So to that I would say until somebody comes up with a better system, we should stick with the one that's worked for over 200 years, which is the best we have, which is to ask them and rely on their statements under oath about their inner thoughts and feelings. I mean, if we have to read their mind to know what they're really thinking, they could be thinking a lot of things that could potentially disqualify them as jurors, not just related to guilt or innocence, but lots of other biases. So we obviously don't have a crystal ball, we don't have the ability to do that, and until we do, all we can do is ask them and rely on them, which I observe jurors to take their oath seriously and to report as well as they can their inner thoughts and feelings on the subjects that we're inquiring about.
The defendant's motion concludes with a citation from a concurring opinion in the Irvin case about the inability of a juror to set aside information that has saturated the media. Here again, this statement was authored in 1961 when it was possible for a media outlet to permeate a community in a way that is no longer possible. Irvin is, of course, still good law, as are all of these old cases that we're talking about. But as Your Honor pointed out, it's your decision it's within your discretion to make a decision based on the circumstances of this case that are present today, which are significantly different from 1961, in which very few women sat on juries because they were only eligible if they voluntarily registered with the clerk, expressing a desire to be placed on a jury list. That's how we did jury selection in 1961. How many volunteers do you think we'd get if we ran jury selection in that manner for everyone?
Things have changed. Time moves on.
In addition, in the Irvin case, that took place in Gibson County, Indiana, population 30,000 back in 1961. Again, very different from the demographics that we have here and the population we have to choose from here. One consideration suggested by the Rollins Court is whether the media coverage in this case has been particularly inflammatory. And I mentioned that. I think the podcast could potentially rise to that level, and we certainly should inquire of the jurors whether they have been exposed to things like that. But on page 7 of her own motion, the defendant offers 12 bullet points of what she presumably considers to be the more inflammatory local headlines, none of which are particularly unusual, and only 2 of which mention her specifically by name. The motion goes on to state that her name and image could evolve into an unconscious, negative, conditioned stimulus when associated with words such as murderer. And we digress there into an absurd result where the media can no longer report who in the community has been arrested for murder without creating a unconscious, negative, unconditioned stimulus such that nobody who reads that newspaper can participate in jury duty. In conclusion, today's media landscape is a smorgasbord of opinion, news, fake news, and everything in between. For better or worse, most of us navigate that information jungle to seek out or at least train the algorithm to feed us the stuff we want to see, the stuff we want to consume, rather than being fed, in 1961 in Indiana, what the editor of the local newspaper wanted us to learn. I mean, I get golden retriever videos. I've probably gotten 367 golden retriever videos, and I certainly couldn't recite 80% of them, for your honor, if a gun was to my head. As evidenced by the prior jury selections and the related trials in this case, there just aren't that many jurors that are saturated with local media anymore. Just because the local media is churning out a lot of material doesn't mean that our jurors are consuming or retaining or forming opinions based on that material. There is a local community interest in seeing justice to be served in this case, and there's not a legal basis to move it. The jurors that have been exposed will be appropriately questioned and stricken based on their answers, but it is a bedrock principle of American criminal law to try the case in the jurisdiction where the crime occurred. The defendant has failed to show that Leon County is inherently prejudiced against her, and as such, the state asks that you deny the motion, proceed to jury selection here in Leon County.
Well, as the relief that you're asking for, is it possible also for the court to reserve ruling and still have the jury selection?
You asking me?
I'm asking you.
I think so, Judge. I think you might have to readdress it if you attempt to pick a jury and cannot seat an unbiased jury in this case.
Mr. Zellman, any response?
Yes, Your Honor. First, Your Honor asked the state some questions about the jury selection in Mr. Charlie Adelson's case.
What was the breakdown of no knowledge, some knowledge, or could set knowledge aside for who was picked?
So I'm reviewing Mr. Charles Adelson's initial brief on appeal. That brief indicates that there were 130 potential jurors that were interviewed on an individual basis. Of those, 96 had heard about the case. Of those 96, 53 believed that he was guilty. I
Those
believe-
persons were never actually selected to serve on the jury.
Correct. The brief does not give a breakdown of,
Who was actually selected?
correct. Now, I will say, Your Honor, that Your Honor will recall that there was one potential juror who claimed a lack of knowledge about the case. And in fact, that individual had posted negative.
I recall who. He was also shown the door.
Yes.
Therein, what is the prejudice?
Well, that just begs the question, does that mean that any time you have a case such as this, you have to hire a consultant such as the one that Charles Adelson hired so that you can get that information and be able to present it to the court? I don't think that that is the way that we should look at things, Your Honor. Now, in response to the state's other arguments, the state has presented no evidence to contradict the studies that are cited in the defense memorandum. Historically, courts have attempted to mitigate the impact of pretrial publicity by conducting that individual voir dire. Unfortunately, the research concludes that that type of attempt to mitigate pretrial publicity is ineffective. Although I recognize that that is the approved, the courts historically have approved that method. However, the psychological research that is identified in the memorandum all stand for the proposition that that's just not how things work with the human brain. Just because somebody asks you, have you seen an article about Professor Markel's murder? Have you read any of the articles concerning Mrs. Adelson's alleged involvement? Have you formed an opinion? Unless you call somebody's attention to the specific article, it might not trigger that memory. That's what the research shows.
Before you go on that point, and I think in that way, this is where the constitutions have the interplay with each other. Obviously, Florida can offer more procedure or process than what the federal constitution requires.
Yes, sir.
As federal juries are selected, the judge essentially drives the process, questions of venire. Does not the Florida procedure give you more rights and more ability in terms of how that jury is selected to drill into those issues of bias?
Yes, Your Honor.
Go ahead.
I'm not going to comment further, but yes, Your Honor. The procedure in Florida does give us more protections than if we were trying this case in federal court.
So between a pre-screening and then also a full questioning, you still believe that bias cannot be ferreted out?
Given the way that the human brain works, I do believe that, Your Honor. I will say, Your Honor, and this is contained in a footnote in my memorandum, if the court, it's footnote 3, if the court decides to defer ruling or to deny the motion, the defense would request additional peremptory challenges as was approved by the court in Hoy.
Very well. I will review all of the exhibits that were admitted as a part of the hearing today that I was not able to do so prior to the hearing. I believe the jury selections for McBenowa and Charles Adelson are the state's exhibits. The charts and graphs that previously were updated or I did not have access to. A written ruling will be issued. We are in recess.
Your Honor, can we reserve to file a supplemental affidavit to address the concern that Your Honor raised at the beginning of the hearing?
You may.
Thank you very much, Your Honor. Sure.
I mean, they're jump drives, so I'm never gonna really put a sticky on. Okay. Get the state's jump drive. That's the defense's. Yes, we'll need it back. Thank you.
Do you care for paper copies of the cases I sent?
Sure. Still like to do the old person thing and hold it and read it.
Trees are already dead.